Good evening, everyone. I am Ragini Rajpur, Research Scholar at Department of Law, Central University of Karnataka. Welcome you all on the behalf of Department of Law. Today's guest speaker is Professor Rajesh Kumar Malik. He is the Dean School of Law at Central University of Haryana. I welcome you, sir. And among us, our coordinator of the department is also here, Dr. Baswaraj Kubukadi, sir. I welcome you, sir, too. And our esteemed sir, Anand sir is also here. I welcome you all to today's session. This is the third lecture of this online human rights law lecture series. I welcome you all. With this, I'll hand over the session to Febin. He will be introducing our today's speaker.
Good evening to one and all. Here. Today, we all have gathered here to be a part of this human rights law lecture series.
Febin, can you be louder? Your voice is not audible.
Good evening.
Can you be a little louder? Thank you.
Good evening. Can you hear me now? Hello?
Can you be a little louder? Maybe try speaking on speaker. Don't use earphones.
Hello, ma'am?
Yes, it is better now. Yes, it is better now.
Okay. Good evening to one and all present here. Today, we all have gathered here to be a part of this human rights law lecture series. The motive of our lecture series is to give an awareness about human rights to all the participants who are gathered here. It's my privilege to introduce our esteemed resource person, Professor Rajesh Kumar Malik of Central University of Haryana. So, I humbly welcome you to take over the session on the principles of natural justice. Hello?
Yes, Fabin, please continue. You're audible.
Yeah, ma'am. So, I humbly welcome you to take over the session on principles of natural justice. Hello, ma'am.
Professor Rajesh Malik, sir. Sir, can you hear us?
Yes. Yes, Dr.
Yes, sir.
Malik,
You may start the lecture. Thank you, sir.
I'm not able to hear Fabin.
Okay.
Could I start with that?
Yes, sir. You may start with the session.
Oh, okay. Because I was not having the idea whether he has completed the things or not. So first of all, thank you one and all, specifically Dr. Basavaraj, Dr. Mandeep, and our Fabin for introducing me with all the participants. Rather, it is a matter of great pleasure for me to be the part of your this human rights lecture series. So today, the topic of discussion is the principles of natural justice. The topic has been chosen with the motive that the topic is such that it is connected with the human rights, and it can be considered as such a principle which is useful not only for the service personnel, student. It is having importance even for the common man. When we talk about the principle of natural justice, see, first of all, when we have to think about the justice, meaning of the justice, it is really such a complex issue which cannot be answered in a precise way, in a scientific manner, because we all know that winning of the case and losing of the case can't be the parameter whether justice has been done or not. So when we talk about the justice, if we talk about the meaning of the justice, in the eyes of the common man, in the eyes of the person of ordinary prudence, or you can say the literal meaning, it is something distinguishing truth from the lie, wrong from the right. And you all know that this is very difficult. When we are there, we have to distinguish wrong from the right, truth from the lie. And if we are able to do that, then definitely we are able to do the justice. If we talk about in formal manner, when we talk about the natural justice, it is a great humanizing principle intended to invest with the fairness in the actions. And when we talk about whether the justice has been done or not, it depends upon so many things. It depends upon the nature of the case. You can say facts and circumstances of the particular case, the nature of the inquiry, nature of the court, the place, and even the parties. So there are many factors involved to find out whether the justice has been done or not. So whether justice has been done or not, it will be depending upon fact and circumstances of a particular case. So when we talk about the principle of natural justice, I would like to tell you that the principle of natural justice has been made the basis of the power of the judicial review by US Supreme Court since long. I will remind you about the famous case of Madbury v. Madison, when the power of judicial review by US Supreme Court was exercised. Even we all know that the power of judicial review is not the part of the US Constitution. Unlike that, power of judicial review is the part of the Indian Constitution enumerated under Article 13. But unfortunately, Indian courts were unknown to this aspect that the principle of natural justice can also be made the basis for the judicial review. If we talk about the early 20 years of the judicial history, there was only one ground on which the power of the judicial review was exercised, that was the ultra vires rule. And that ultra vires rule was also confined to the legislative action only. It was not extended to administrative action. It was not extended to executive action. So it was for the first time in 1978, when in the case of Menka Gandhi versus Union of India, the Supreme Court exercised the power of the judicial review by making principle of natural justice as a basis. From that day onwards, principle of natural justice has become the part of the Indian Constitution. Now, what are the principles of natural justice? We have three main principles of natural justice. First is rule against bias. That is, we can say, nemo debet esse judex in propria causa. In English, we call it rule against bias. Second is addi alteram partem, means hear both the sides. And third one is the reasoned decision. You can say that the speaking order. When we talk about the first principle of the natural justice, that is rule against bias, from the language that nemo debet esse judex in propria causa, it means no one can become judge in own cause. Other phenomena, that justice not only to be done, must see to be done. And third, justice like Caesar's wife. So rule against bias is based upon these three things, that justice not only to be done, must seem to be done. Then justice like Caesar's wife, and no one can become judge in own cause. The question is, what is bias? When we talk about rule against bias, so bias means predisposition in the mind of the deciding authority, either to do something in favor of someone or to do something against someone without considering the merit of the case. When we talk about the biasness, there are basically three kinds of biasness. One is personal biasness, second is pecuniary biasness, and third one is official bias or institutional bias or the subject matter bias, whatever you call it. So first, personal bias. When we talk about personal bias, it means when the deciding authority is going to get some benefit out of the decision to be made by the deciding authority, it will be considered as a case of personal bias. Means here, the deciding authorities are personally benefited either by deciding something in favor of someone or against someone. In this, I would like to discuss with you case of A.K. Karpak versus Union of India, when the whole selection process of Union Public Service Commission was quashed by the Supreme Court on the ground of the personal bias. So in Indian history, this is only and only the instance or example when the whole selection process of UPSC was quashed because there was a case of personal biases. Other case, in the case of Kinkari Devi versus State of Himachal Pradesh, there also where the member of the departmental promotion committee was itself a candidate. In that case also it was considered that it is a case of the personal biasness, and undoubtedly the Supreme Court gave the observation that the candidate is fully eligible, but it lacks that justice not only to be done, must seem to be done. It is very difficult to tell the public that no doubt that he is member of the departmental promotion committee, but he is fully eligible. So it was required that he should withdraw himself from the departmental promotion committee. And when we talk about the case of A.K. Karpak, their member of the UPSC himself was a candidate for selection in UPSC. He was selected, and in that case, the Supreme Court considered it as a dual biasness. How dual biasness? Supreme Court said that his colleague members, while interviewing him, awarded him more marks and awarded less marks to the other candidate. So on that ground, it was considered that it is a case of the personal biasness. Then comes the pecuniary biasness. When we talk about the pecuniary biasness, when the deciding authorities are itself getting some pecuniary interest, getting some monetary benefit out of the decision to be taken by that authority. In this regard, we have a famous case, Dr. Bonhomme of the Oxford University, R versus Oxford University, you can say, that Dr. Bonhomme was the professor of medicine, and as per the rules of the Oxford University, no one was allowed to go for the private practice without the permission of the university. But Dr. Bonhomme was having the private practice after the working hour. A departmental inquiry was constituted against him, and departmental inquiry punished him with some pecuniary amount. He challenged it on the ground that it is a
His voice is breaking up.
He left the meeting. Participants, kindly wait. He might join again. His network was not working properly, I think.
Okay, ma'am.
Hello.
Yes, sir. Now you're audible. Your voice was not coming.
Yes. I think there was some network issue in between. I was connected on the other system also, but in the meantime, it was connected. Are you able to hear me now?
Yes, sir. Properly.
Okay. I think I left with the pecuniary bias, if I'm not wrong.
Yes, sir. You were talking about the case of Dr.
Bonhomme. Dr.
Yes, sir,
Bonhomme.
Yes, sir.
Okay. One more thing I wanted to ask, whether everyone is comfortable in English?
Yes, sir. Yes, sir.
Okay. There should not be some sort of injustice. We are talking about the principle of natural justice. We should not cause injustice to the participants. So that's why I wanted to ask if there is some problem in the English, we can use Hindi also in between. But I'm of the view that people must be comfortable in English. Okay. So there in the rules of the university, there was a provision that whatever the fine will be imposed upon the delinquent, 50% of that amount will go to the university exchequer and 50% will go to government exchequer. So Dr. Bonhomme challenged the decision on the ground that it is a case of the pecuniary bias because the deciding authorities were going to get benefited out of the decision directly, because the more fine they will impose, more will be the share of the university, and that's why whatever the amount of the fine, that is $50,000 or so, that has been imposed upon him, is totally having the subjection of the pecuniary bias, and the court agreed to it. Yes, it is a case of the pecuniary bias, and the decision was quashed. And same is applicable even in case of our country also, that even if a pecuniary biasness of the 1 rupee, then the Indian Supreme Court has also followed the decision given in the case of Dr. Bonhomme. So then when we talk about the third bias, that is official bias, you can say, institutional bias, you can say, subject matter bias, you can say. It means when the office itself is going to get benefit out of the decision, when the institution is going to get benefit out of the decision, when the subject matter is such that it is going to give some benefit to the deciding authority, it can be the case of the your official bias, institutional bias, or the subject matter bias. Here I would like to narrate a famous case in Haryana only. In Haryana, it was a case of Krishna Bus Private Limited versus State of Haryana. So here in Haryana, Krishna Bus Private Limited used to ply their buses from Delhi to Bhiwani and Hisar. Haryana came into existence in 1966. In 1967, Haryana government made the rules that the power of checking buses will lie with the general manager of the roadways. Earlier, that power was with the police when Haryana Punjab was joined. But when the Haryana came into existence, the power of checking of the buses was given to the Haryana Roadways general manager. So that rule was challenged by Krishna Bus Private Limited on the ground that general manager of Haryana Roadways himself is plying the buses, and when he has been given the power, what he will do, he will put the lame excuses in order to put some challan, in order to put some fine on our buses, and he will not take any care about the buses of the Haryana Roadways, even when those buses are having certain shortcomings, certain fault, etc. So giving the power to General Manager Haryana Roadways is a case of the institutional bias, and the decision required to be quashed being unconstitutional. And our Supreme Court agreed to it. Yes, it is the case of the institutional bias, official bias, General Manager Haryana Roadways cannot check the flying of the buses because he himself is going to get some benefit if Haryana Roadways is having the more earning during his tenure as a general manager. So this is the case of the your institutional bias or the subject matter bias. So this is our first principle, which is based upon three things: that justice not only to be done must seem to be done, then justice like seizure swipe, and you can also that a person cannot become judge in his own cause. Then we talk about the second principle, that is adi alteram partem. It means here both the side. Here when we talk about the hearing of both the side, it is having two requirements. One is the notice, second one is the opportunity of hearing. So whenever any complaint against one is coming of any nature, this principle says that first and foremost thing which is required to be done is that a notice must be given to the person against whom the complaint has been made. That we call generally so-cause notice. That whenever a complaint is coming, it is sent to the person against whom that complaint is made, that these are the allegations against you. What you want to say, you clarify your position, that why action should not be taken against you on the basis of the allegation level in the complaint. Then, on the receipt of the reply from the person against whom the complaint was made, that reply is to be studied. If that reply is satisfactory, the complaint should be filed. No further action is required to be taken. However, if prima facie, it looks, yes, there are certain substances in the complaint, prima facie case has been made out, then the process of conducting the regular inquiry in service matter, we also call it departmental regular inquiry, that is to be conducted. And in that regard, this principle of natural justice says, first step which is required to be taken is that the issuance of the charge sheet. A person, a delinquent, against whom action is to be taken, he or she should be issued with the charge sheet, and that charge sheet should have the complete details regarding the memo of the charges, regarding the statement of the allegations, regarding the witnesses, if any. So the whole document is to be prepared, and that should be sent to the delinquent. Then delinquent must be asked to give reply to the charge sheet. When he or she submits the reply to the charge sheet, then the employer has to decide whether further inquiry is required to be conducted or not. If the employer is satisfied with the reply of the charge sheet, then again the case can be closed here, the complaint can be filed. However, if the employer is not satisfied with the reply, employer now can appoint the inquiry officer. Now, as per this principle, now inquiry officer first has to provide every opportunity to the delinquent, and that start with producing of the documents, whatever available with the delinquent regarding his or her innocence, then producing of the witnesses which can helpful to the delinquent to prove his innocence, then cross-examination of the witnesses of the other party, and sometimes there may be such situation that the document, the material relating to the innocent of the delinquent may be under the possession of the other party or even the third party. Then the inquiry officer will ensure that those documents are produced for the referral, for the perusal, for the consideration of the delinquent. After following this procedure that first provide every opportunity regarding the producing of any document, witnesses, cross-examination of the witnesses of the other party, and getting the document which are under the possession of the other party, then the inquiry officer has to reach to the conclusion whether some punishment is to be recommended or not. If it is so, then the inquiry officer has to give its finding whether delinquent is held guilty or not, whether he has been held guilty to what extent, for major penalty or for minor penalty. So in this way, whether he is held guilty for all the charges or whether he is held guilty for few charges. This everything is to be mentioned. And when inquiry report has been submitted by the inquiry officer, employer is not bound by the report of the inquiry officer. Inquiry officer may there is one demand from Aditya Kumar to speak in Hindi. Aditya, let me complete in English a brief idea I will be giving in Hindi. After
Yes,
this,
sir. I only ask you that this case only you describe in Hindi, sir. That I think that
cases. See, after discussing all the three principles, I will be giving a brief idea. And cases I will be telling in 5 to 10
okay,
minutes.
sir.
The actually after completing the three principles, actually we will be reaching to some stage. So, the employer can disagree with the report of the inquiry officer. He is not bound by the report of the inquiry officer, but the employer has to tell specifically on which point he is having disagreement with the findings of the inquiry officer. And if the employer says, yeah, reach to the conclusion that the inquiry officer has tries to favor the delinquent and disagrees on one particular point, then again, the whole process is to be repeated regarding the disagreement. If there is a disagreement of one point, again the whole process, if the delinquent will be provided every opportunity to defend himself regarding the disagreement of the employer. After that only, it is to be decided by the employer whether major penalty is to be imposed or the minor penalty is to be imposed. So this is your second principle of the principle of natural justice, that is the alteram partem. Sometimes there may be question that when we talk about the opportunity of hearing, what type of hearing, whether it should be personal hearing or otherwise. See, nowhere it is mentioned under the principle of natural justice that such nature of hearing can be there. So it will be depending upon the fact and circumstances of the case, whether personal hearing is required, whether other nature of hearing is required. So that will be totally depending upon. But only thing is, when we talk about the opportunity of hearing, it must be the reasonable opportunity of hearing. Means opportunity of hearing should not be such that mere formalities are met, formalities are carried out. And this reasonable word was also used under the Constitution of India after the 44th Amendment, when the second stage hearing was excluded. That time it was ensured that now it is one hearing only, so that hearing should be reasonable opportunity of hearing. So this is your second principle. Then when we talk about the third principle, it is a modern principle. Earlier we were having only two principles of natural justice. That is, first one, as I told you, non mutatis judice in propria causa. No one can become the new cause, in English you can say. And second is ad alteram partem, means here both decide. But now we have the third principle, that is the modern principle of the natural justice, that is reasoned decision. It is also called that speaking order. It means the third principle says that every decision must be supported by the reasons. Means whatever decision has been taken by the deciding authority, they must have the reason. They must have the justification beyond that decision. Or in other words, that decision, that order must speak itself. You all know, we all know that order can't speak. But when we talk about speaking order, means the order is having such reasonableness, the order is having such type of content, such type of clarity, certainty, logical coherence in such a way that there is no scope of any doubt. If it is so, then it will be a speaking order. Many times, you will find that whenever any writ is filed either under Article 226 or under Article 32, on many of the occasions, court used to dispose of the writ on the first hearing itself, only on that the employer, or you can say the respondent, should pass the speaking order within a period of 2 months, 3 months. Here, why the court are doing so? First, giving an opportunity to the authorities to decide the case on the merit, making it specific, and second, a jolt to the person who has approached to the court, that in case he has approached to the court on falsify ground, again he has to file the court case and he has to pay the fee of the advocate and otherwise also, so that a person does not approach to the court with the casual attitude, with the careless things in the mind. So for that purpose, the writ is disposed of with the direction that speaking order to be passed. So it is that speaking order that is to be required under the third principle of natural justice, that the authority must pass an order which must speak itself, must be supported by the reasons. So these are the three principles of the natural justice. I have given brief only for the thing because discussing directly importance is not going to get the result or not going to solve the purpose until and unless we do not know the principle of natural justice. Just in 5 minutes, for the sake of our participants who are Hindi speaking, are more comfortable in Hindi. देखिए आज हमारा विषय नेचुरल जस्टिस का है। सबसे बड़ी बात तो नेचुरल जस्टिस से पहले ये आती है कि जस्टिस है क्या। बड़ा मुश्किल है डिफाइन करना, एक साइंटिफिक डेफिनेशन नहीं दे सकते, प्रिसाइज डेफिनेशन नहीं दे सकते, और हम इसको केस हारने और जीतने के साथ भी जोड़ नहीं सकते हैं, क्योंकि हार और जीत में बहुत से फैक्टर्स इन्वॉल्व होते हैं। सही मायनों में आम आदमी की नजर में जैसे हम कहते हैं कि दूध का दूध पानी का पानी कर दिया, तो यानी कि हम सबको पता है कि दूध को पानी से अलग करना कितना मुश्किल काम है। इसी ढंग से न्याय करना भी, जस्टिस करना भी इतना ही मुश्किल कार्य है। अगर आम भाषा की बात करें, मीनिंग की बात करें, तो सच को झूठ को अलग करना, गलत और ठीक को अलग करना, यही एक न्याय है। और जब हम प्राकृतिक न्याय की बात करें तो ये भी एक बड़ा मुश्किल है कि प्राकृतिक न्याय क्या है। क्यों? प्रकृति के अनुसार न्याय आपने करना है। प्रकृति के अनुसार न्याय का मतलब हर केस के सर्कमस्टांसेस अलग अलग हैं, उनको ध्यान में रखते हुए आपने न्याय करना। और नेचुरल जस्टिस एक बहुत बड़ा ह्यूमनाइजिंग प्रिंसिपल है। उसकी इन्वेस्टमेंट टोटल की टोटल फेयरनेस से है कि ताकि किसी के साथ इनजस्टिस को बचाया जा सके। अब न्याय, प्राकृतिक न्याय हुआ या नहीं हुआ, ये जो है किसी केस के हालात के ऊपर, किस तरह के रूल्स हैं, किस तरह की कोर्ट है, कौन सी जगह है, पार्टीज कैसी हैं, ऐसे बहुत से फैक्टर हैं जिसके ऊपर हम ये कह सकते हैं कि प्राकृतिक न्याय हुआ नहीं हुआ। तो प्राकृतिक न्याय के 3 सिद्धांत हैं। सबसे पहला सिद्धांत रूल अगेंस्ट बायस, मैंने बताया कि भाई किसी भी तरह की बायसनेस का मतलब यह है कि किसी के हक में या किसी के खिलाफ बिना मेरिट की। तो अगर हम बायसनेस की बात करें कि एक पूर्व धारणा है डिसाइडिंग अथॉरिटी के मन में कि मैंने इसके हक में करना है, क्योंकि ये मेरा मित्र है, ये मेरा रिश्तेदार है। एक पूर्व धारणा है डिसाइडिंग अथॉरिटी के मन में कि ये मेरा दुश्मन है, इससे मेरी बनती नहीं है, मैंने इसके खिलाफ करना है। तो ये जो है बायसनेस है। तो बायसनेस तीन तरह की है। पर्सनल बायस की मैंने बात की कि जब जो है व्यक्ति खुद डिसाइडिंग अथॉरिटी का हिस्सा है, उसको खुद अगर फैसला एक तरफ लेने से उसको अगर फायदा हो रहा हो तो उसको हम जो है पर्सनल बायसनेस कहते हैं। मैंने एक का केस आपके साथ डिस्कस किया। यूपीएससी में जो यूपीएससी का मेंबर था वो खुद ही एक सिलेक्शन के लिए कैंडिडेट भी था और उसका सिलेक्शन हुआ तो उसके सिलेक्शन को चेंज किया गया, तो सुप्रीम कोर्ट ने उसके सिलेक्शन को ही गलत नहीं ठहराया। सुप्रीम कोर्ट ने जो है ये कहा कि पूरा का पूरा यूपीएससी का जो सिलेक्शन प्रोसेस है इसको हम क्वेश्चन करते हैं, क्योंकि न्याय करना ही नहीं है, न्याय दिखाई भी देना चाहिए था और इसमें हमें लग नहीं रहा कि यूपीएससी ने कोई न्याय किया है। और दो तरह की जो है इसके अंदर बायसनेस हुई है। अपने मेंबर के तो उन्होंने ज्यादा मार्क्स दिए ही है इंटरव्यू में, दूसरे लोगों के कम भी दिए हैं। तो हमारे भारत के इतिहास में एकमात्र केस है जिसमें यूपीएससी के पूरे सिलेक्शन को क्वेश्चन किया गया है और वो भी प्राकृतिक न्याय के सिद्धांत के है। मैंने शुरुआत मेरी इसी बात से की थी कि यूएस की जो सुप्रीम कोर्ट थी, आप सबको पता है कि भाई यूएस के सुप्रीम कोर्ट में अमेरिका के संविधान में जुडिशियल रिव्यू कहीं पर भी मेंशन नहीं है, लेकिन वहां की सुप्रीम कोर्ट पावर ऑफ जुडिशियल रिव्यू प्राकृतिक न्याय के सिद्धांत को आधार बना करके जो है एक्सरसाइज कर रही थी। और मैडबरी वर्सेस मेडिसन जैसे केसेस उन्होंने प्राकृतिक न्याय के सिद्धांत के आधार पर दे दिए थे। लेकिन हमारे देश का दुर्भाग्य था कि पहले 20-25 साल तो हमारी सुप्रीम कोर्ट ने एक ही आधार बना के रखा, वो अल्ट्रा वायरस रूल, कि जब कोई अथॉरिटी बियॉन्ड पावर जाएगी तब हम पावर ऑफ जुडिशियल रिव्यू को एक्सरसाइज करेंगे, अदरवाइज हम नहीं करेंगे। और वो भी उन्होंने लेजिस्लेटिव एक्शन तक अपने आप को सीमित रखा था। एडमिनिस्ट्रेटिव एक्शन, एग्जीक्यूटिव एक्शन के बारे में वो कभी भी उन्होंने बात नहीं की थी। पहली बार मेनका गांधी के केस में जो है प्राकृतिक न्याय के सिद्धांत का प्रयोग किया गया और उसको आर्टिकल 14 का आपके राइट टू इक्वलिटी, समानता के अधिकार का जो है हिस्सा माना गया था। तो दूसरा मैंने बायस की जो काइंड थी वो ये थी कि पेक्यूनरी बायस, यानी कि जब डिसाइडिंग अथॉरिटी को पैसे के रूप में कुछ फायदा हो रहा हो। मैंने वहां का आर वर्सेस ऑक्सफोर्ड यूनिवर्सिटी का एग्जांपल दिया कि डॉक्टर बोनहेम वहां पर प्रोफेसर थे और डॉक्टर बोनहेम बाहर प्रैक्टिस करते थे, उसके खिलाफ डिपार्टमेंट की इंक्वायरी हुई, इंक्वायरी में उसको गिल्टी होल्ड किया गया और गिल्टी होल्ड करने के बाद उसके ऊपर $50,000 का जुर्माना लगा दिया। उसने उस डिसीजन को चैलेंज किया कि जी ये जो 50,000 का जुर्माना लगाया गया है ये एक रूल है जिसमें ये है कि जितना जुर्माना लगेगा उसका आधा पैसा यूनिवर्सिटी के पास आएगा और आधा पैसा सरकार के पास जाएगा। तो इसलिए डिसाइडिंग अथॉरिटी तो ने तो ज्यादा से ज्यादा फाइन लगाया मेरे ऊपर, तो क्यों? उनको खुद फायदा हो रहा था, तो वहां कोर्ट ने माना था और वही प्रिंसिपल को हमने भी जो है यहां पर जो है उसको अप्लाई किया। इसी ढंग से सब्जेक्ट मैटर बायस का या इंस्टीट्यूशन बायस का मैंने बताया कि जब खुद ऑफिस को फायदा हो रहा हो। हरियाणा का मैंने एग्जांपल दिया कि हरियाणा के अंदर कृष्णा बस सर्विस चलती है दिल्ली से हिसार और भिवानी के लिए। उन्होंने केस को डाला कृष्णा बस सर्विस प्राइवेट लिमिटेड वर्सेस स्टेट ऑफ हरियाणा कि हरियाणा बनने के बाद उन्होंने बसों को चेक करने की पावर हरियाणा रोडवेज के जीएम को दे दी थी। तो कृष्णा बस सर्विस वालों ने यही कहा कि जी रोडवेज जीएम तो खुद अपनी बसें चलाता है हरियाणा रोडवेज की, उसका फायदा होता है तो उसको इंक्रीमेंट मिलते हैं, उसकी शाबाशी होती है, और नुकसान होता है तो उसके एडवर्स होता है। तो इसलिए वो क्या करेगा, हमारी बसेज में कोई कमी नहीं होगी तो वो कमी निकालेगा, उनकी बस में कोई कमी नहीं होगी उसको दरकिनार रखेगा। तो इसलिए ये जो है एक गलत है ये रूल, इसको पावर देने का। सुप्रीम कोर्ट ने माना इस बात को बिल्कुल सही है और हरियाणा गवर्नमेंट के रूल को क्वेश्चन किया। तो ये तो था फर्स्ट प्रिंसिपल रूल अगेंस्ट बायस का। दूसरा मैंने कहा था कि एट द अल्टर पार्टम हियर बोथ द साइड्स, यानी कि किसी के खिलाफ एडवर्स एक्शन लेने से पहले जो है दोनों को सुनना जरूरी है, किसी को बगैर सुने हमने कंडम नहीं करना है। तो उसमें दो चीजें हैं, पहले एक नोटिस दिया जाए। आप सबको पता है कि प्रजातंत्र है, डेमोक्रेसी की एडवांटेज है तो वहां डिसएडवांटेजेस भी हैं, और सबसे बड़ी डेमोक्रेसी के अंदर यह है कि आप कैसी भी शिकायत किसी के भी खिलाफ कर दो। इसी ढंग से जो है सच्ची शिकायतों के साथ झूठी शिकायतों का भी एक बहुत बड़ा ढेर होता है। तो उसी बात को ध्यान में रखते हुए हमारा ये सेकंड प्रिंसिपल ये कहता है कि जब भी किसी के खिलाफ शिकायत आए, आप सबसे पहले उसके पास भेजिए कि ये आपके खिलाफ एलिगेशन है, आप बताइए क्यों ना आपके खिलाफ कार्रवाई की जाए। उसके जवाब को लीजिए, जवाब से संतुष्ट होते हो तो आगे कोई कार्रवाई करने की जरूरत नहीं है, एप्लीकेशन को फाइल कर दीजिए, कंप्लेंट को फाइल कर दीजिए। लेकिन यदि आपको लगता है कि नहीं कुछ तो है, तो उसके बाद उसके अंदर चार्जशीट आप जो है इशू करिए उसको। चार्जशीट में जो जो उसके एलिगेशन है उन सब की स्टेटमेंट, क्या डॉक्यूमेंट के ऊपर रिलाई कर रहे हो, क्या विटनेसेज हैं, वो सारा का सारा उसको दीजिए, फिर उससे रिप्लाई लीजिए। अगर उससे भी आप सेटिस्फाई नहीं होते हो तो उसके बाद इंक्वायरी ऑफिसर लगाइए। इंक्वायरी ऑफिसर लगाने के बाद भी इंक्वायरी ऑफिसर पहले उसको पूरा मौका दिएगा, कोई कागज देना है उसको कागज देगा, कोई गवाह लेके आना उस गवाह लेके आएगा, और दूसरी पार्टी का गवाह है उसको क्रॉस एग्जामिन भी करेगा। कई बार कुछ कागजात किसी ऑफिस के अंदर हो, दूसरी पार्टी के पोजीशन में हो, तो अगर वो ये कहे कि जी मेरी तो इनोसेंस उस कागजों में है, तो वो इंश्योर करेगा कि वो कागज भी मंगाए जाए। उसके बाद कोई ना कोई फैसले पर जो है इंक्वायरी ऑफिसर पहुंचेगा, और जब इंक्वायरी ऑफिसर को रिकमेंड करेगा कि किस किस दोष के लिए इसको दोषी उसने पाया है और क्या पनिशमेंट, मेजर पेनल्टी देनी है या माइनर देनी है, उसको वो रिकमेंड करेगा। उसकी रिकमेंडेशन हालांकि जरूरी नहीं है नियोक्ता के लिए कि माने, लेकिन यदि नियोक्ता एग्री नहीं करता है तो पार्टिकुलर पॉइंट बताना पड़ेगा कि इस पॉइंट पर मैं एग्री नहीं करता, डिसएग्री करता हूं, और जो जिस पॉइंट पर डिसएग्री करेगा दोबारा से फिर जो है डेलिंक्वेंट को पूरा मौका दिया जाएगा। उसके बाद ही जो है कोई किसी तरह का उसके खिलाफ कार्रवाई की जा सकती है। और तीसरा मैंने जो सिद्धांत बताया वो यही था कि रीजन डिसीजन स्पीकिंग ऑर्डर, यानी कि आपका फैसला ऐसा हो जो कारणों से जो है सपोर्ट हो, या ये कहिए कि भाई आपने हर जस्टिफिकेशन है कि आपने ये फैसला क्यों लिया। आपका ऑर्डर ऐसा है जो मुंह से बोले, ऑर्डर कभी मुंह से नहीं बोलता, लेकिन ऑर्डर की खासियत ये है कि वह उसके अंदर किसी भी तरह की कोई शक की कोई गुंजाइश नहीं है, किसी तरह का कोई ऐसा नहीं है कि कोई अनरीजनेबलनेस है। तो ये था हमारा तीसरा प्रिंसिपल जिसको हम मॉडर्न प्रिंसिपल कहते हैं। तो ये 3 प्रिंसिपल थे नेचुरल जस्टिस के जो मैंने अभी बताए। अब हम इनकी इंपोर्टेंस की बात करेंगे। आदित्य, और तो कुछ नहीं बचा जो हिंदी में बताने का हो?
नो सर।
हाँ, चलो, ओके, सो वी शुड कंटिन्यू विद द इंग्लिश। When we talk about the importance of the principle of natural justice, undoubtedly services are the backbone of a nation. The efficiency in the service directly reflects the society at large, directly reflects the development of a nation. So in order to ensure the efficiency in service, there must be a balance between the security of tenure and the accountability. When we talk about the security of tenure means a person must be provided security so that she can work without any fear, without any favor, and accountability so that the dead wood can be removed from the services as early as possible. In order to ensure the efficiency in service, we have 3 types of service in our country. First one is the government services, which you call public services. Second is public sector services, and third one is the private service. So let us come to the first type of service, that is government services, or you can say public services. Under Indian Constitution, we have the full chapter that is services under the union and state, that start from your Article 308. And if you take the whole chapter, it starts up to 323, but don't take up to that. Even if we talk about the basically directly connected with the services, that Article 308, 309, 310, and 311. These 4 articles are directly deals with 2 aspects: doctrine of pleasure and constitutional safeguard. Doctrine of pleasure has been invoked for the purpose so that the dead wood can be removed from the service. Means a person holding the civil post will remain on the post during the pleasure of the President of India or the governor, as the case may be. Means if it is the central services, obviously pleasure of President of India. If it is the state service, pleasure is of the governor of a particular state. So this is dealing with pleasure, is dealing with accountability. Then constitutional safeguard, they are dealing with the security of tenure. And whatever we have discussed in the second principle of the natural justice, ad alteram partem, both the things are required while dealing with the safeguards to civil servant. Means in case of the safeguard, 2 main safeguards. First is a person cannot be dismissed, removed, reduced in rank by an authority lower than the appointing authority. Second, before dismissing, removing, reducing the rank of a civil servant, a person must be provided opportunity of hearing. When we talk about the opportunity of hearing, before 44th Amendment, there was 2-stage hearing. First one was at the time of the issuance of the charge sheet, means framing of the charges. Second stage was at the time of inflicting the punishment. But by 44th Amendment, the second stage opportunity was withdrawn. Then a big issue arose whether opportunity of hearing will be reasonable or not. So in number of cases, let be Purushottam Lal Dingda versus Union of India, Tulsiram Patel versus Union of India. In both the cases, Supreme Court said that the hearing must be the reasonable. And any hearing will be reasonable when it is meeting the requirement of the second principle of natural justice. So in order to make the opportunity of hearing reasonable, all the steps which we have discussed, that issuance of the so-called notice, getting the reply, then issuance of the charge sheet, appointment of the inquiry officer, providing the opportunity to produce documents, witnesses, cross-examination, and then getting the document under the possession of the other party. If such steps are taken, then definitely it will be the reasonable opportunity of hearing. So principle of natural justice have made the reasonable opportunity of hearing for the civil servants. Undoubtedly, when we talk about the opportunity of hearing, there are 3 circumstances when no need to give opportunity of hearing. And those circumstances are when a person has been convicted, yani ki conviction on a criminal charge. Sometimes act is such, at one side it is misconduct under the service law, on the other side it is an offense under the criminal law. So when both the things take place, practical, I am telling you, what employer does, employer used to constitute the inquiry, does not move further, wait for the outcome of the criminal case. If the delinquent is convicted there, then employer need not to provide any opportunity of hearing, termination of the service, dismissal of the service can take place. But if person has been acquitted there, now the ball comes in the hand of the employer. Now employer can proceed further with the departmental inquiry. I would like to tell you, acquittal in a case does not entitle the employee that no action under service law should not be taken. Action can be taken under service law even when a person has been acquitted. Because in case of acquittal, it is never considered that the person is innocent. Acquittal means there may be benefit of doubt, and you all know that criminal jurisprudence, benefit of doubt goes to the accused. So that never means that when a person has been acquitted, that he is innocent. Departmental action can be taken. I would like to tell you the case of even Haryana. A police constable was teaching a woman in a bus. A criminal case was registered against him. Later on, a compromise arrived at between the victim and the accused, and he was acquitted. After acquittal, meantime, superintendent, he was in the police department, superintendents of police dismissed his services. After acquittal, he went to superintendent of police that I have been acquitted by the court, and now get me the reinstatement, allow me to join the duty. But superintendent of police said, no, I will not allow you to join the duties for the one simple reason: you are not worth to become a policeman, because your duty is to protect the dignity of a woman. Your duty is not to tease a woman by yourself. So you are not fit to become a policeman. Against the decision of the superintendent of police, he approached to the High Court of Punjab and Haryana High Court. Punjab and High Court agreed with the superintendent of police and said that yes, the decision taken by superintendent of police is legally valid because he is not worth to be a policeman. Against the decision of the Punjab High Court, SLP was filed in Supreme Court. SLP was also dismissed by the Supreme Court. So, acquittal does not entitle reinstatement. However, conviction deprives the person a right of the opportunity of hearing. So, second exception to the opportunity of hearing is your interest, national interest. When it is in the interest of the nation, when the security of state demands that prompt action is to be taken. In that circumstances also, there is no need to provide the opportunity of hearing. You might have seen in the newspaper 5-6 months back, one of the officer of the RA in Afghanistan, having some sort of relationship with the officer of Pakistan. She was called from that place. At the moment she landed in India, she was dismissed from the service without holding any inquiry, because it was in the interest of the nation, it was in the interest of public that a prompt action is to be taken. So when national interest comes, security of state comes, public interest comes. Another example was there that a woman in police station was raped by the police personnel, and all the police personnel were dismissed from the service without holding any inquiry, because it was the demand of the public interest that prompt action is required to be taken. This is the second exception when the opportunity of hearing is not to be given. And third is holding of inquiry not practicable. When it is not possible to hold the inquiry, when sometime you will find that allegations are against some senior officials and it is to be proved by some subordinates, very difficult to get any evidence against the superior, against the boss, against the person sitting at the high place. And if it proved that a holding of inquiry is not practicable, in that circumstance also opportunity of hearing is not required to be given. It is an exception to the opportunity of hearing. However, the principle of natural justice is of the paramount consideration while deciding a case of the civil servant, public servant, or government servant, whatever you call it. So all the constitutional provision, whether there is a violation of the fundamental right or any other legal right, it is to be seen with the eyes of the principle of the natural justice. Same, is the case of the public sector undertakings. You all know when we talk about the public sector undertakings, we are dealing with the major part with the public corporations. We are the employees of the university. We are coming under this category, that is public sector undertaking. Earlier, if we take the long back, the employees of the public sector undertaking, even not having the right to approach under Article 226 and the 32. It was only after that, when the expansion of Article 12 as a state took place, after that only the employees of the public sector undertaking were allowed to exercise the right under Article 226 and the 32. At the time, even after that, principles of natural justice were coming for the rescue of the employees of the public sector undertaking. Undoubtedly, they have the statutory rule on the pattern of the provisions which we have discussed under the Indian Constitution. But main role in case of the employees of the public sector undertaking was played by the principles of the natural justice. And when we talk about the private services, let it may be the workmen dealt under the your Industrial Dispute Act, under the Companies Act, under the Employees Standing Order Act, under the Factories Act, or any other law. They are having protection of only and only of the principle of the natural justice. No other law, no other remedy under the law is that much efficacious.
Yes, please. Kalyan, he is going to join.
Hello? Are you able to hear me?
Yes, sir, you're audible now.
Oh, okay. It was some network issue. So, even you might have got one statement that right to property is more secured in present form as a constitutional right when it is compared right to property as a fundamental right. It is said by 2-3 jurists or the professor of the law. Why they have said? They have said only due to the principle of natural justice. Because when in the case of Menka Gandhi, the principle of natural justice were made the integral part of the right to equality. So here under Article 300A also, application of the principle of natural justice. आवाज आ रही मेरी? हेलो,
Yes, sir.
Sir,
आपकी आवाज आ
sorry.
रही है.
हाँ, कोई लिंक कोई मेरे पास भेज देता कि लिंक नहीं है, समथिंग लाइक दैट was coming. Okay, so there it was written that a person shall be deprived of the property save by authority of law. In fundamental right was that no person shall be deprived of the right to property save by authority of law. Here it is that a person can be deprived of the property by following the procedure of law. So what happened after the case of Menka Gandhi, when the natural justice came into existence? First, it was that undoubtedly a person can be deprived of his right to property, but for that there must be a law. And then, while depriving a person of his right to property, there must be the payment of the reasonable amount of compensation for acquiring the property for public purpose. And you all know that as per the principle of natural justice, the amount can be reasonable only when the payment for acquiring a property for public purpose is paid as per the market rate. So whatever the right to property we are enjoying in the present form, it was only due to the implementation of the principle of natural justice that when you are going to deprive, okay, deprive, government has the right, there is a eminent domain, government can deprive a person from his or her property, can acquire the property for public purpose, but government is bound to make the payment for that. And when we talk about the payment, that payment must be reasonable. When it can be reasonable? When it is as per the market rate prevalent in that particular locality. So it was only after the case of Menka Gandhi when the principle of the natural justice became the part of it. And at present, see, that was the time of the Official Secret Act 1923, when principle of natural justice was an exception. Secrecy was the main principle. Exception was principle of justice. Means until and unless it was specifically mentioned in a statute, in a law, that authorities are bound to follow the principle of natural justice, authorities were not bound. Now the situation is reverse. Until and unless it is specifically mentioned in a statute, in a law, that authorities are not required, are not bound to follow the principle of natural justice, authorities are bound to follow the principle of natural justice. So, at present, let it be the accountability, let it be the openness, let it be the transparency. It is the principle of natural justice which has promoted to all the aspects. And let it be your right to know. And in present form, we have the right to information. That credit goes to the principles of the natural justice only. That today we are in a position that not only to know about the information, not only to know about the decision of the authority, we are having the right to know the reasons while a particular decision has been taken. So you are not having only right to know the decision, you are also having the right to know the reasons of the decision taken by particular authority. So in this way, the principles of natural justice are not only helpful for the service personnel, principles of natural justice are helpful for the ordinary person, are also in their every aspect while exercising their right, let it be case of the fundamental right, while exercising the writ jurisdiction under Article 32 or 226 or otherwise. And in case of the your employees, definitely the principle of natural justice has become a great safeguard in addition to the statutory remedies available to an employee. So this was from my side about the principles of the natural justice. Obviously, I would like to know the feedback or the questions from your side. If you have any confusion, any ambiguity, anything not cleared by me, you are not able to understand, you are most welcome.
Good evening, sir.
Good evening, madam.
So before we proceed to the question and answer round, initially Fabian could not tell your introduction properly. Can we have it now, if you don't mind?
Ma'am, I think there is no need. It's all right. See, one thing I told you, our introduction is our interaction with the participants. If we are able to meet their requirement, if we are able to, do something useful for them, that is the introduction for us.
Right, sir.
If we are not able to meet their requirement, all our decoration, I should say, which we have associated with by virtue of some time, by virtue of certain opportunity, are useless. So only my request to the participants, if they are able to get something, please let me know. If you have any query, please let me know.
Participants, if you have any questions, either text in the chat box or ask, sir.
Hello, sir. Adarsh here.
Yes. Hi, others.
Sir, I have some questions.
Yes, please.
Sir, you said in a case a person is convicted, it deprives some such person from right to opportunity of hearing. Does that not amount to violation of basic human rights of an individual? Because, sir, I feel that no law should be above the human rights. It was, I feel, correct me if you are wrong, sir.
Pardon, please tell once again, please repeat.
Sir, you said in a case a person is convicted, it deprives such person from right to opportunity of hearing.
Yes.
Does that not amount to violation of basic human rights of an individual?
Okay. No. See, others, why it is taken? Because when we talk about the criminal trial, you know that the opportunities in the criminal trial to the accused are many times more when it is compared to the opportunity under the service law.
Okay, sir.
Because their advocates are able to help the person. A complete procedure is there under the Evidence Act, which the courts are bound to follow. So it is considered by the law that when he could not get the benefit of the doubt at that place, there is no scope that he can prove his innocence under the service law. See, under service law, there is no term like benefit of doubt. But then you know that criminal jurisprudence says benefit of doubt will go to the accused.
Yes.
Here we will go for the strict interpretation of the service law. But there, even if any lacuna in the case of the prosecution will be helping the accused. So that's why it is considered.
Okay. Sir, thank you, sir. Thank you so much.
Welcome. Yes, Aditya.
Sir, I have a question that, sir, as you said that it is written in the, as it is not written in the constitution that judicial review, there is no any format written in the regarding the judicial review. But my question is that, sir,
आदित्य, मेरे ख्याल आप थोड़ा सा कंफ्यूज कर गए. मैंने ये बात कही थी कि अमेरिका के कॉन्स्टिट्यूशन में कहीं पर भी जुडिशियल रिव्यू नहीं लिखा हुआ है. अमेरिकन कॉन्स्टिट्यूशन का हिस्सा नहीं है, लेकिन उसके बावजूद भी यूएसए की सुप्रीम कोर्ट जुडिशियल रिव्यू की पावर को एक्सरसाइज करती थी. किस आधार पर? प्रिंसिपल ऑफ नेचुरल जस्टिस को आधार बढ़ा के. और अनफॉर्चुनेटली हमारे कॉन्स्टिट्यूशन में आर्टिकल 13 में कैटेगरिकली मेंशन है पावर ऑफ जुडिशियल रिव्यू. लेकिन हमारी कोर्टों ने पहले 20 साल पावर ऑफ जुडिशियल रिव्यू को एक्सरसाइज नहीं किया, अपनी लिमिटेड ज्यूरिडिक्शन, एक अल्ट्रा वायरस रूल, अल्ट्रा वायरस मतलब बियॉन्ड पावर, उन्होंने कभी भी इस बात की तरफ नहीं देखा कि जी प्रिंसिपल ऑफ नेचुरल जस्टिस को आधार बढ़ा ले। एक ही बात कही कि नहीं जी, यदि कोई अथॉरिटी बियॉन्ड पावर गई है तो हम इंटरफियर करेंगे, अदरवाइज हम इंटरफियर करेंगे। और भी किस मामले में? सिर्फ लेजिस्लेटिव मैटर में। अगर लॉ मेकिंग बॉडी ने अपनी लिमिट क्रॉस की है तो हम रेस्क्यू के लिए आएंगे, अदरवाइज नहीं आएंगे। मैं आपको एग्जांपल देता हूं एक गोपालन के केस का।
यस सर, पता है
एक गोपालन बेचारा अरेस्ट कर लिया अंडर प्रिवेंटिव डिटेंशन लॉ, वो रो रो के मर गया कोर्ट के अंदर कि जी मैं कोई ऑफेंस नहीं कर रहा था, मैं घर में खाना खा रहा था, पुलिस मुझे जबरदस्ती उठा ले आई है और ये गलत है। लेकिन सुप्रीम कोर्ट ने हाथ खड़े कर दिए कि वी आर नॉट सपोज टू नो दिस थिंग। हमें तो एक बात, हाँ हमें तो एक बात पता है कि भाई पुलिस, हाँ
दिस इज अ लेजिस्लेटिव प्रोसेस है,
हाँ कि भाई आप तो बस वो है जी, हम इसमें नहीं जाएंगे, हम इस पचड़े में नहीं पड़ेंगे। लेकिन मैं कहता हूं कि मेनका गांधी के बाद सारी चीजें आई, उसके बाद तो ड्यू प्रोसेस ऑफ लॉ और प्रोसीजर एस्टेब्लिश बुलाई एक चीज होगी थी।
यस सर, यस सर,
ठीक है ना, तो वो कह रहा था मैंने इंडियन, हाँ
सर ऐसे जो जुडिशियल एक्टिविज्म है वो भी मतलब नेचुरल जस्टिस के प्रिंसिपल को तो थोड़ा बहुत फॉलो करता है वो सर।
सी हालांकि जुडिशियल एक्टिविज्म इज नथिंग, इट इज लाइक ए जुडिशियल रिव्यू, रादर जुडिशियल रिव्यू ही है। तो देयर इट इज एक्टिविज्म ऑन द पार्ट ऑफ द जुडिशरी एंड इट लुक्स एक्टिविज्म when there is a failure of the executive or legislature to perform its duty। कुछ भी नहीं है, मतलब ठीक, the judiciary is the arbiter of the constitution, judiciary is the protector of the little man, and it's the duty of the judiciary to protect the little man if there is a failure of the executive or the legislature, and that has been done. But undoubtedly uniform policy was not followed by the judiciary. That was the reason some sort of questions came that there is some sort of pick and choose on the part of the judiciary. Otherwise, whatever we call judicial activism, it is nothing like activism. It is the judicial review only. Powers are exercised as a judicial review only.
Yes, sir.
There is a failure of the executive to perform duty, or there is a failure of the legislature.
Yes, sir. Yes, sir. Thank you, sir. Okay, sir. Thank you.
Any other thing?
Good evening, sir.
हाँ, गुड इवनिंग, बताइए शिवेश पटनायक।
Yes, sir.
हाँ.
Sir, I have posted my question in the chat. So it's regarding when there is a conflict between, let's say, statutory provision and principles of natural justice.
Yes.
In an emergency situation, for example, when the legal rights of a human being are infringed, which one will prevail, sir, in this case?
See, statutory rights may have certain limitations, but there is no limitation on the principle of natural justice. So generally you will find hardly there is any possibility that some sort of controversy can be there. Even if so, then a person has to be given benefit under the principle of natural justice, because principle of natural justice is having a broader connotation. Statutory, you have seen in the case of Maneka Gandhi, there was a provision
Yes, sir, yes,
under the Passport Act that the passport authority can deprive a person from the passport without signing any reason. Good, my point. Their principle of natural justice has come for the rescue. मतलब कोर्ट ने यही तो कहा ना कि आपने लिख दिया और काम हो गया है. What about the principle of natural justice? Okay, so in that situation, principle of natural justice will prevail over it. And as I have told you,
Sir,
now it has become the
Yes,
part of the Article 14. When they have become the part of your fundamental right, very basic right, obviously it is having the superseding effect over all other legal rights. Good, my point.
So, if let's say there is a, let's say if we talk about an exception when it comes to administrative jurisdiction,
Okay.
in that case scenarios also,
Discretion.
yes, sir.
See,
in that case scenarios also natural justice will prevail.
okay, yes, I see.
was my point.
When we talk about the discretion, basically, discretion does not mean arbitrary exercise of the power. Discretion means giving various alternatives to the deciding authority. And it is the duty of the deciding authority to ensure that the best alternative mode has been selected. But undoubtedly, it is confused with the arbitrary exercise. We authorities
And
are also
rationals
thinking
given.
in such a way that discretion means it is my wish and will. No, discretion does not mean will and whims. Discretion means that you are not asked to follow one particular procedure, one particular alternative while taking a decision. You are giving a discretion, but that discretion must be exercised on the sound principle of reasonableness.
Got it,
Got
sir.
my point?
There's a clear distinction between the arbitrariness and the
Yes.
distinction between
Well,
the
that should not be confused with that one. Definitely, when there is a, that's what the reason. Otherwise, when discretionary power was granted, legislature never intended that power should be subject to judicial review. But the other side also, Lord Denningham rightly said, when the legislature has intended to give the discretionary power, never intended that power will be, restrained or questioned in a court of law. But unfettered power cannot be given to anybody. More the liberty, more the freedom, there is a possibility more is the abuse of the power.
more
So
there
it-
is abuse of the power.
abuse. In order to keep the authorities with the limit of the power, to ambit of the power, the discretionary power are also subject to judicial review on two circumstances. One is the failure to exercise discretion, and second is the excess or abuse of the discretion. In the case of failure, you all know that acting under dictation, self-imposed rule, something like that. And in case of excess or abuse, exceeding jurisdiction, culpable exercise of the power, violation of the principle of natural justice is also one of the grounds.
Natural justice, the exception.
Yes,
sir.
so yeah, this is there.
Thank you very much.
Okay. Yes, any other thing?
Good evening, sir.
Good evening.
So, I have one question that when Chief Justice Deepak Misra was CJI, he constituted a bench to hear a case that indirectly implicated himself itself a criminal conduct. Thus, is violating the cardinal principle of no person shall be a judge in his or own cause principle. What is your opinion in this point, sir?
Yes, Uma, you are absolutely right. See, that was totally wrong on his part, because he cannot become judge in his own cause. Let the complaint may be false. He was bound to exclude himself from the whole process, and it was required on his part to give the command to next person in seniority to decide the future course of action. Though I would like to tell you that was not also not in right spirit, because till he is Chief Justice of India, so, next person in the seniority can't go against him. So the best mode is that he should not exclude not only from the process, he should come out of that organ also, if really we want to implement the principle of natural justice. He has to recuse himself from the whole process. Should not be the part of that system who is going to conduct an inquiry. That is only the issue not going on presently, that there is no complaint mechanism. You might be going through a collegium system, and the other, there is some sort of tussle between the government and Supreme Court. So here main contention is that after appointment, there is no complaint mechanism. And situation we have seen that when there is a complaint against Chief Justice of India, where is the independent body? Where is the mechanism to deal with such type of people? It is not there. So it was wrong on his part. We will not go into the merit whether the complaint was true, false, some politics, something like that. Keep everything aside. But definitely justice not only to be done, must seem to be done.
Okay, sir. Thank you, sir.
I have a doubt, sir.
Yes, Prem. Don't tell your
Sir,
doubt.
I am
We will try
audible.
to.
Sir,
Yes, yes,
first
you
of
are.
all, thank you for sharing such a. Sir, first of all, thank you for sharing such a great knowledge on the subject. Really, you
Thank
had
you.
a great knowledge.
Thank you.
Sir, actually, my doubt is. Sir, actually, my doubt is there is basic principle that no person is guilty unless it is proved.
Yes.
But how can there be a contradictory exception to that? That a person is deprived of something which he is entitled of, even though if he is acquitted. Is it not something harsh?
No. See, Prem, we have to see intention of the framers, legislature, and the spirit of the law. Undoubtedly, a person is innocent till guilt is proved. But at the same time, there is that if a person, if you will remember, I started my lecture with the thing that losing and winning of the case does not mean that justice has been done. So we cannot, equate with it when if you have won the case, that justice has been done. Not at all. And losing the case does not mean injustice has been done. See here, what was only the requirement of the law is that when a criminal trial takes place, there it is a very lengthy procedure. Every opportunity is available to the accused. So when the accused is not able to get his innocence, then definitely opportunity is not required. Other thing which you have said, that when a person has been acquitted, why he should not be considered in the service matter? See, things are seen from the different angle. That person was in the police. One thing I would like to tell, I ask from you people, I use two terms. One is the dismissal, yani ke dismiss, other is termination. Is there any difference between the both? कोई बताएगा फिर आप?
Yes.
हाँ हाँ आदित्य.
Sir, what are the 2 points that you say, sir? Termination and
Dismissal.
हाँ sir, termination and dismissal.
क्या फर्क?
Sir,
What is the difference?
no sir, इसमें there is no any difference. There is a difference between termination and suspend, but dismiss, no difference.
See, we are from the field of law, and every why is to be replied.
So there is a difference, sir. Can I
हाँ
explain, sir?
बताइए, उमाकांत बताइए.
So dismissal, after dismissal, a person is not suitable for re-employment in any government service. Whereas after termination, a person may be re-employed. And there are severe, that's why dismissal is called as capital punishment under service rules. It's the most stringent punishment.
See, when we talk about the dismissal, generally you will find a person is dismissed only in the case of moral turpitude. What are the cases of moral turpitude are mentioned by the government, state government, even at the central government from time to time, that these cases will be covered under moral turpitude. Termination means making an end to particular appointment, employment, whatever you call it. And dismissal means making an end to that employment as well as debarring a person from holding any position under the public services, public sector services. And even nowadays, private people are also not allowing such persons. See, I gave you the example of constable. There, that person was not worth to be a constable for the reason that the main function of the policeman is to provide security, protection to the common man. and if himself is indulged such type of activities, at least that person is not fit for that job. Sometimes we may commit an act, we may not be able to perform the role of teacher, may not be fit for teacher, but we can perform some other roles. So that was the only reason that when a person is involved in teaching, involved in rape, may be acquitted, but not fit for to hold the post of a policeman. क्यों? हाँ,
Yes, sir.
प्रेम, हाँ मकान तो आपका तो हो गया, प्रेम का सवाल था ये.
Thank you, sir.
Anything else from any other person?
Brijesh, you wanted to ask a question? Please ask your question here. Puran Randhawaji, you wanted to ask a question in the initial section. Puranji?
Yes, Rajesh also has raised a hand, but I think no, we are not able to connect with him. Any other? If I have not seen in the box.
Brijesh and Puran Randhawaji? I think we're not able to connect to them. Okay, if anybody else do not want to ask any question, we'll proceed with the next.
So, are you able to get something which we have discussed, whether your interaction with me was some fruitful or not? Let me ask one question from you. Or we have wasted 1.5 hours?
No, sir, this is very fruitful for all of us.
See, madam wanted to give the introduction about me, and that's why I asked not to give any introduction. That if I'm able to share such type of views which may be new for you, or maybe some, something add in your existing knowledge, then that is the proper introduction for that. Otherwise, my philosophy is of no use for you people.
You were right, sir. It was extremely interesting session. We enjoyed, gained a lot through it. Thank you for inculcating cases in your session. I think some Krishna has a question. You may ask.
Sir, why is that service rules differ that much from criminal justice system to that extent that few of the principles of natural justice are not applied?
Please pardon. Once again.
Sir, why is that service rules differ that much from criminal justice system to that extent that few of the principles of natural justice are not applied?
Where?
Sir,
In service? In service?
Yes, sir. Yes, sir.
See, it is applicable, but I have told you only certain circumstances when the opportunity of hearing is not to be given. See, individual interest, there it is not like criminal. Individual interest and social interest, or you can say national interest, are compared there. You all know that we have the one term that there may be supremacy of directive principle over fundamental right. Elucidate this statement. You might have got question in LLB also. Means when we are dealing with Article 39B and C, though they are the part of the your directive principle which are neither enforceable nor justiciable, still they are having supremacy over the fundamental right. Reason is very simple. When there is a conflict between the individual interest and social interest has to be prevailing. When there is a conflict between the individual interest and the national interest has to prevail. So only for that purpose, these exceptions are given in order to give supremacy to the social interest over the individual interest. Otherwise, criminal jurisprudence and service jurisprudence both are entirely, different subjects. Here we are dealing with the civil rights. There we are dealing with your right to life and the personal liberty, that is right of the person, property and limb, etc. Entirely different, having no connection at all.
Okay, sir. Thank you, sir.
Okay. One more participant was raising a question. Sorry, hand. ठीक है? We should conclude.
I think everybody else has asked the questions. Sir, we'll now proceed with Kaushalya. Kaushalya, I invite Kaushalya for the vote of thanks.
Before Ragini, I just want to say something.
Ji, Dr. Saab.
Sir, this is Anand from faculty of Department of Law, Central University of Karnataka.
Oh.
Very happy to see you and very happy to listen you, sir. In fact, in the recent days, indeed, I feel like it's one of the very interesting, and you have given very information to all our participants. So thank you on behalf of the Department of Law, sir.
Thank you, Dr. Anand.
And I'm looking forward similar kind of a cooperation and your guidance to the department. Indeed, our is the very new department. This is just 3-year-old department. So we need your cooperation, guidance in all our future endeavors.
Sure. Whenever you will be in need of my services, either through virtual mode or personally, I will be with you people. And see, one thing I will believe, undoubtedly, when I start with the teaching, our socialist pattern, I used to say that the caste system is the root of our society. But which caste? Not the caste by birth, caste by profession. So it is my pleasure, and I feel always pleasure when I'm required to do something for my discipline. So we are from the same caste, from that angle, and it will be my pleasure if I can do something for the development of your department, your personal development, and I will feel happy. And one thing I would like to tell Dr. Anand, I'm not such a teacher that whenever you need my service, I will think whether you will able to pay the bus fare, whether you will able to pay me train fare, whether you will be able to pay me airfare. No, whenever you are in need of my service, I can come to you, I can reach to you without any fear and all. Only the thing that if I'm able to help you people in right perspective, that is the real service to the, and I think that should be the quality of a teacher. So it will be my pleasure any time, on any occasion, in any role, need not to worry, unhesitantly. You are at the liberty to ask me to do anything.
So kind of you, sir. So kind of you.
Thank you.
It is your humbleness. It shows that your personality. You are so humble. In fact, when I was listening about the introduction, you said like interaction itself is an introduction of your.
Yeah, see, Anand, that is only there. See, I may have the plethora of the knowledge. If I'm not able to deliver to you, the participant, and specifically I'm not able to make the event useful, then all that decorations which have been associated only for that we should pray to the God, that God has given us opportunity and these things are added in our profile.
Yeah, definitely.
Nothing more than that. Otherwise,
few people think like this, sir.
Yes, see, that is a variety of the society, and we should not see.
Exceptional to that.
Nice.
So patient, sir. And definitely I'll reach you, sir, personally. And definitely we'll be in touch.
Sure. Most welcome. और I think Madam Ragini को मैं जो है मनदीप कौर बोल गया था, some name was coming on that side, Mandeep Kaur. I thought that the name will be Mandeep, so please excuse me for that.
Ragini is
now I
very
see the name that
in
Ragini Rajbhar.
Yeah.
Okay.
Yeah, yes, Ragini and our research scholars and all our students who are doing very well, sir. and
Right.
definitely with your guidance, they will
Definitely
succeed
my
in their
my
future
my,
career, sir.
my best wish is my sport. वो कहते हैं vote and sport both are with you.
Yes, thank you, sir. Yes, sir. Thank you. I'll definitely read you, sir.
And yes, Ragini deserves the special thanks from my side. She has handled the things in a beautiful manner.
True, sir. True, sir. Very true.
We
Now,
pray for her bright future. My best wishes are with you.
yeah. Now over to Ragini and over to Kaushalya. Thank you, sir.
Oh, thank you, dear.
Thank you, Rajesh, sir. Thank you, Anand, sir. Kaushalya, please proceed.
Yes, sir. Good evening, sir. Good evening, respected sir, and good evening, my dear beloved professors, and good evening, everyone. I'm Koribeli Kaushalya, studying LLM second year, Central University of Karnataka. It has been such a privilege to be a part of this lecture and honor to propose a vote of thanks. Already, Anand sir give a vote of thanks on behalf of the department. Once again, I'm also doing the same thing on behalf of Department of Law, Central University of Karnataka. I would like to extend my heartful gratitude to our today's speaker, Dr. Rajesh Kumar Malik, Professor and Dean, School of Law, Central University of Haryana, who gave us his valuable time, sir. And sir, you covered all the aspects of principles of natural justice with the help and also importance of our services. And also clearly explained about the three principles of our natural justice with the helping of the case laws of India and also other countries too. And you also discussed about how the common citizen get justice with the help of principles of natural justice if their rights are violated by the civil servants or else a public sector or a private sector something. And you truly make this day full of knowledge for us, and your deep and intellectual way of conveying the subject has added to the glory of this lecture, sir. And it is a really an informative lecture in a true sense. And I believe that many of us here will benefit from your lecture, really. And also, thank you very much, sir, to clarify all the doubts of the participants. And once again, thank you so much, sir.
Thank you,
Next,
Kusila. Thank you.
Yes, sir. Thank you, sir. Next, I would like to thank our head of the department, Dr. Basras Kubkardi, who took the initiative for this kind of lecture series. And really, thank you so much, sir. And I would like to thank to Dr. Anand D. Chinjore, sir, Assistant Professor of Law and Coordinator of IQAC, Department of Law, for the part of this lecture series. Last but not least, I thank all the participants from the various institutions and fields for enthusiastically participating in the lecture series. Thank you once again. Thank you so much.
Thank you, Kaushalya. Thank you, Rajesh, sir, for considering our request to be a part of this lecture series. Thank you so much.
Thank you. Thank you.
Participants kindly fill the feedback form. Thank you so much. Enjoy your day. Bye-bye.
Thank you, ma'am.
Thank you.
Thank you.
Thank you, sir.